I am back, and I am ready to talk about this case.
People were asking where you were, so you were visiting your parents.
Yeah, and it became a very complicated situation.
Yeah.
Couldn't have been here last time, but this case came out during that time frame, and, so you made comment on it earlier.
Well, it had just literally come out.
Pretty much the day it dropped.
The day it dropped, and I read a few things that deeply, deeply concern me, and I'll probably reiterate some of them.
Well, you're not the only one. There's a bunch of people saying this is terrible. So the case we're talking about is RV Rioux, Rioux, 2025 SCC 34. That's Supreme Court of Canada. And this was I believe it was on our Cases to Watch in our newsletter.
That's correct.
And
God bless that newsletter.
I know. Well, and it was definitely a case to watch because it was dealing with two main issues that are kind of unresolved to some degree, and this one attempts to resolve one of them, although it kind of puts off another one. So it has to do with a situation in which a complainant has a lack of memory and also kind of alleges circumstantially that they might have been drugged.
Right.
And so what do we make of that? Because the Crown hasn't actually charged the accused in this case, and many others that we've seen. They're not charged with drugging, and that's an actual charge, administering a noxious substance. So that's not an actual charge. The Crown's not saying that they can prove that. Yet the circumstantial evidence clearly is alleging that the complainant is saying, I think I was drugged. And it's never really resolved because it's not a charge. And so then that becomes a big question is like, how do you determine whether or not...
Well, if I read this correctly, and I don't want to, because I know you have a whole thing prepared for this, so I'm going to shut up more during this episode. But just while you're mentioning this, the issue about drugging is a very insidious issue, because without any toxicology, you can simply say, because of the way I was feeling, I believe I was drugged. And then that can be some evidence upon which a court can maybe consider as a whole to conclude that you were f***ing drugged? Am I reading this wrong?
No, that's really what they're saying, is they can conclude that you were drugged even though there's no toxicology. And to be fair, there are a number of drugs that, if you don't report straight away, can be eliminated from your system and be undetectable. So
there's no doubt that some date rape drugs metabolize very quickly, and so unless you're tested in very short order, you'll not find the metabolites in either urine or traces in blood. So I get that. Totally get that. If there's delay in going to the hospital and taking blood samples. What I'm concerned about is, without any other evidence, for example, I saw him pouring something into the drink. I thought maybe it could be another liquor, but it wasn't really coming from a bottle I recognize. So that could have been a drug. Without some evidence of that nature, I was reading this, and maybe incorrectly, and again, Well,
in this case, I believe she said, I only had 2 drinks, and that's not usually enough to get me intoxicated.
I get that, but my point is this. Is it enough, based on this case now, that based upon the person's feelings, that would be enough to conclude that the person was drugged? So you're raising the point now, I only had 2 drinks. Normally, that's not enough to get me intoxicated, or certainly intoxicated to this extent.
So, fact specific to this case, and this is important to mention because...
So it's not answered.
No, it's not.
That worries me.
It's important to recognize that that decisions, when they come out, have specific facts to the case that may not make them comparable to another case in terms of what they're dealing with and grappling with. In this case, there were 2 alleged incidents of sexual assault. One takes place in a park when they first get together and start drinking, and then she ends up being transported, which we'll get to, being transported to his home. And then there's another alleged incident at a home. So going into this appeal, the accused was acquitted by the trial judge of both incidents. And the Crown only challenged the first incident in the park. And the judge had found that he believed that the complainant had no capacity to consent on the second occasion, but believed that the accused had honest but mistaken belief in consent.
Right.
So the only thing before them was whether or not the first incident should be sent back to trial. They did not have an option to send the entire thing back to trial.
Okay.
Because of the nature of the appeal.
Yeah.
But, there was evidence from the complainant in this case where she said in her testimony that she was so disoriented that she tripped on rocks and injured herself. And then when she was being transported from the park to his home, that she had to be carried, quote, like a sack of potatoes. Mm-hmm. And in this case, one of the concerns the Supreme Court had was that the judge did not grapple with circumstantial evidence from her, even though she had a memory blackout, that the judge didn't grapple with this evidence about whether or not she tripped on rocks and had to be carried in that manner. Mm-hmm. So that's a difference from a complete void of evidence, where somebody says, oh, I remember I went out to a park and I had 2 drinks and I have no idea what happened. There was some evidence from the complainant about being so disabled and disoriented that she was injuring herself and had to be carried. Mm-hmm. That reasonably, and we'll talk about circumstantial evidence, because this is an important decision about circumstantial evidence, not just by a complainant, but also from an accused person. Mm-hmm. That's one of the things that they were dealing with, and it plays a role in it. So there's, on the surface, and we've kind of talked about this in terms of this decision has a lot of lemons in it, but there's also a little bit of lemonade that can be helpful for accused people as well.
What do you want to start with? Because I think there's a lot of lemons.
Let's start with the lemons.
Okay. Do you want to start off?
Well, I'm more positive, so
I know. I'm very curious what you say.
So I'm going to have to flip to the lemons. So, in paragraph 74, they say that that this case is subject to limitations on direct evidence from an accused regarding the complainant's subjective state of mind, which is addressed in further paragraphs later on. So this is a big concern we have about how consent is subjective to the complainant and whether or not an accused can actually offer evidence about her actual consent.
That's the first major lemon.
That's a major lemon. And this is important because the original case talking about consent being subjective state of mind is a Wanchuk. And they made it clear in a Wanchuk, but it's kind of overlooked, very much overlooked in a lot of cases we deal with, that a Wanchuk always made it clear that a complainant's subjective claim of subjective state of mind, saying I didn't want it and I wouldn't have consented, is subject to credibility. So that testimony, and of course an accused person nobody can say what somebody else was thinking, only the person can say what they were thinking, but it's still subject to credibility assessment.
Right, and one of the maybe it's my reading, but when I look at how the majority cast the issue of consent, where the complainant cannot give direct evidence of her subjective consent because of memory loss or blackout, the inability to articulate her state of mind, or because she was drugged, intoxicated, ill, or had certain physical or mental conditions, proof of the actus reus will rest almost exclusively on circumstantial evidence. Okay? The evidence can come from the complainant, witnesses, or documentary proof. An accused testimony should not be treated as direct evidence of the complainant's state of mind. I understand that. Only the complainant can provide direct evidence of her subjective consent. For the purposes of the actus reus, the accused's perception is irrelevant. The accused is legally unable to provide direct evidence on the complainant's consent. I think that's problematic.
I'm a little distracted because I'm so proud of our firm that we can hear the printer going. Somebody's still here working.
Yeah, that's right.
So if you hear a noise in the background, that's because we work hard.
Yeah. So consent, so her state of mind is a subjective issue. Mm-hmm. But whether you provide consent is a matter of credibility. Correct?
Right. And so there's two factors. There's what she says is going through her mind, but the accused can still offer circumstantial evidence about her actions and words.
Right, but clearly, to be clear on the law, I'm not going to...
And you brought up too, like this issue about, lack of memory. And this is an important thing to get into, is like a lack of memory is not the same as being unconscious. That people have
Or
blackouts.
a blackout, which caused me concern.
People have blackouts or even brownouts where they have partial memories, but they could still be dancing on a table and then say, I did what? But they did it, and there's tons of witnesses to it. So
Okay, can I just step back for a sec? Because
Yeah.
I want to I just want to stay on this one sentence, which I'm worried about.
I just want to say, no, you can't.
Okay, well, thank you. A complainant's evidence that she did not consent is a matter of credibility to be weighed in light of all the evidence, including the complainant's words and actions before and during the incident, and by reference to the totality of the evidence, including any ambiguous or contradictory conduct by the complainant. And this is uncharged, paragraphs 29-61, okay?
Yeah.
That's the law, so just bear with me, okay? For the purposes of the actus reus, the accused perception is irrelevant. Not sure what that means. The accused is legally unable to provide direct evidence on the complainant's consent. That's not true,
It's not.
right? So they're conflating.
I don't like the use of the word irrelevant. It makes it sound like nothing you have
it's
to
worse.
say matters.
The accused is legally unable to provide direct evidence on the complainant's consent. They're simply saying because on Uanchuk, consent is a subjective analysis. Yes, I agree, but it's still subject to credibility, and you can give direct evidence of what you actually see the other person doing to undermine the fact that they're saying that they did not consent.
I think the point is that what the accused sees and hears her saying is
And frankly, interprets from their actions.
doesn't actually inform us as to what the person was thinking, but it goes more towards honest but mistaken belief
No.
or credibility.
No. It's credibility.
credibility.
Absolutely. This is where this can go really wrong, and we need to be careful about this.
But it becomes more of a credibility issue if the complainant denies.
We need to stop talking about, to a certain extent, what the complainant was thinking. The Crown has to establish the absence of consent beyond a reasonable doubt. Consent is the issue. It's part of the actus reus.
For an example, though, a very clear example, if a complainant says very clearly in her testimony, usually her, if the complainant says in their testimony that they were actively repelling a person, and then the accused person says, no, this person was actually holding my hand and caressing me and all this other stuff, that goes into credibility about difference of actions, then it becomes an issue of who's believed, right?
Okay, but that goes to the issue of consent.
But again, this is more complicated because now we're dealing with an absence of memory.
Just please stop with the absence of memory for a second. This is why the wording here disturbs me. And I don't think I'm reading it wrong. I understand that we have an absence of memory here. I get that. I understand that there's going to be circumstantial evidence. I understand their complaints about what the trial judge did not do. I understand that. I don't like the wording. And maybe I'm being too nitpicky. But yes, I get that the complainant can only provide direct evidence of her subjective consent. Okay, I get that. But for the purpose of the actus reus, the accused perception is irrelevant. No, that's not completely correct. The accused is legally unable to provide direct evidence on the complainant's consent. Let me read you the test again from Uanchuk. Okay? This is the Supreme Court of Canada. Again, the complainant's evidence that she did not consent is a matter of credibility to be weighed in light of all the evidence, including the complainant's words and actions before and during the incident, and by reference to the totality of evidence, including any ambiguous or contradictory conduct by the complainant. Well, you're going to have an accused testify about those very issues, and possibly other people, depending upon the circumstances of the case. So it is relevant to the actus reus because part of the actus reus is consent, and you can provide direct evidence. So if a complainant asserts, I never consented, but the accused is then saying, well, she did the following, and I observed that, and she said the following, and then you happen to have a a voyeur watching as part of this process who then testifies and says, well, I watched her do X, Y, and Z and say the following, which supports the evidence of the accused, is that not direct evidence of her consent?
Well, if you have a voyeur...
No, but is that not direct evidence?
But...
Is his evidence not
his
direct
evidence does matter, and so I'm gonna venture.
You sound like the Supreme Court of Canada.
I'm gonna venture back. Well, I like to play the devil's advocate with you because it makes me so angry.
I think the wording is unfortunate.
Yeah, but there is some lemonade, and I just flipped back a little bit to the issue you were talking about. At paragraph 71, they say, well, central to what the Crown must prove, they do not prescribe or limit how they can be established. So central to what they must prove, but not how it can be established, it is important not to conflate these substantive requirements with the principles of evidence governing their proof. For example, and this is why people have trouble with the law, because it's like this fancy wording, but it does make sense when you look at it closely. They say, for example, important, that subjective consent is personal to the complainant does not mean that only direct evidence from the complainant about her state of mind at that time can be relevant to subjective consent. So, despite all their other stuff emphasizing that only she can testify about it, there is in paragraph 71 a direct acknowledgement that, just because subjective consent is personal, it doesn't mean that only her evidence matters.
I would hope not, because then we would have no way of defending it.
Right. And this is similarly that
this is unnecessarily complicated. This was absolutely unnecessary. Well, you could state these principles in one page without making it this convoluted.
Well, the problem for me is that the law to be followed must be understandable to the general public.
I would hope so.
So they know if they're breaking the law or not breaking the law. And when it gets this complicated and obscure in a way...
Yeah. I was hunched over my laptop all day today with you doing work. So,
but when it gets this complicated and convoluted around what consent means, how in the world is a member of the general public supposed to know if they're breaking the law or not?
Well, I can tell you when the podcast dropped on
last Sunday.
On Sunday, I mean, I was reading comments and I mean, people were incredibly confused by this, and I don't think I was misreading parts of this case. I just think it was made incredibly unnecessarily complex.
Well, I think one of the problems is that, Supreme Court is extremely selective on what cases they hear. And, unless it's by right of appeal, which this case was. And when they do deliver their decisions, it comes across very academic. And, it's almost like they choose cases that are intriguing to them on an intellectual level.
I know, but I've read other Supreme Court of Canada decisions that were well written
they can be very clear, especially if Bachauko's writing them, but he's not in the Supreme Court. He's always very clear.
He should be.
And he makes his decisions accessible to as many future cases as possible, which is what I love about the way he writes his decisions. But really, when you get academic like this, I really think it's important for the Supreme Court to write decisions that help people understand if they're breaking the law or if they're not breaking the law. Mm-hmm. And this case is so obscure and confusing in terms of, so if she says that she thinks she was drugged, but there's no proof of drugging, does that mean that her blackout and her inability to actually offer testimony... I'm going to get into a real big lemon, actually, connected to this. Okay. That all of a sudden her testimony carries this great weight because it's all subjective and she needs to be believed. So one of the big lemons on this... Actually, I've got quite a few listed in here. Mm-hmm. I did try to make lemonade, but there's a lot of lemons. So the court said that consent must be meaningful, which incorporates the question of suggested drugging. One of the areas of litigation that was not resolved is how the court can determine the complainant was drugged when there's no direct evidence of drugging. This decision is based on a presumption that there was a drugging, in a way. Mm-hmm. They don't actually answer the question, and they say, that's not a question to be answered on this particular case, but they kind of assume that it was. And the trial judge declined to make a finding on whether the complainant had been drugged. And that finding was required to decide if honest but mistaken belief evidence was viable. And oddly, the judge found that the complainant lacked capacity to consent at the accused's house, but did not account for her testimony about feeling in a similar state for a few hours earlier during sexual activity in the park. Mm-hmm. What's the average person to make about this? How are you supposed to understand what happened?
I could read this 17 times and I'm still finding it confusing. This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record. And now back to our podcast. Thank you.
There was circumstantial, to be fair, there was circumstantial evidence that she said, as we discussed, that she said she fell down in the park and injured herself, and then she had to be carried like a sack of potatoes. And the judge did find her to be a credible witness and reliable witness. So the problem here is that he didn't grapple with, if he found her credible and reliable, why that evidence of being incapable of walking and being carried like a sack of potatoes didn't affect his decision.
Right. He should have addressed it in his analysis and giving it consideration, which I don't think he did a very good job of, and that's why there was the decision that we have. But again, I'm dealing with the language used by the Supreme Court that I think creates a lot of lemons in the future for how lower courts may interpret evidence and limit an ability to attack a case, particularly where there's a memory loss issue or a blackout.
So one of the things we talked about...
And overemphasize, I think, and give overdue weight to issues that I think are really not that probative. I mean, when they go into a complainant who experienced memory loss can still provide evidence relevant to capacity consent. I'm sorry, this may be a little bit of a repeat of last week, but I wanted Diana to take a crack at this and for maybe to see I'm getting it wrong. But a complainant's circumstantial evidence may include her emotional state before and after the sexual act, her attitude towards the accused. Yeah, okay. Any of her actions inconsistent with consent, her beliefs and assumptions about how she would have acted in the circumstances. That troubles me. Physical evidence inconsistent with consent, fine. Any relevant actions of the accused. The complainant's evidence as to what occurred before and after sexual act is also admissible as circumstantial evidence of her capacity at the time of the sexual act. In addition, courts must consider evidence of outward signs of impairment, including loss of gross motor skills. I mean, that's all fairly basic stuff.
Well established.
Yeah, well established. But I don't think what's well established, and we see this repeatedly, but I think when the Supreme Court emphasizes this too much, when you introduce some alcohol, let's say in a situation where you don't have somebody complaining about this significant state of intoxication, an attitude towards the accused is really not very probative. Her assumptions and beliefs about how she would have acted in the circumstances, I think, is ripe for abuse. Mm-hmm. And manipulation, and I don't think is that probative.
No.
And frankly, Alper had an interesting thing to point out as a articling student. He said, maybe that's based on myths.
Mm-hmm. Well,
even though it would be grounded in the particular complainant, you'd be calling on certain myths to assume, an intoxicated woman who doesn't like the accused wouldn't otherwise have sex with him. Mm-hmm. Her assumptions about how she would have believed and acted in the circumstances, well, maybe absent alcohol. Because I've tried to say this before, and the last time I was going, you introduce alcohol into a situation where, somebody's not incapacitated, and the test for incapacity is fairly significant. It's not like, I'm drunk, therefore I can't consent. We got to be very careful about that. Yeah. So, hang on, just let me finish my thought. So, her beliefs and assumptions about how she would have acted in the circumstances doesn't equate for the consumption of alcohol, because that changes your attitudes and assumptions.
No, we've seen a lot
Does
of
it not?
cases. We've seen a lot of cases where somebody says, I would never have done this. And then they're presented with video of them at a bar doing something that they just asserted they would never have done.
Absolutely.
Right? So just because you wouldn't normally have done it doesn't mean you didn't actually do it.
Yeah, you know what? I'm glad you raised that, because I forgot. There's one case where there was direct evidence, I'm going to use that term, of the complainant's actions while intoxicated. And you weren't around for this. I had this. It was one of these,
There's a case we cite a lot that has a similar situation too, but they changed the name of it to anonymize it.
So I had one of these cases years ago at one of these like 72-hour concert fests, right? And everybody's in tents and campers and everywhere. And so this complainant was talking about her literally was talking about how I would never act this way. I would never have kissed him. I don't know him. I would have never done anything, let alone gone into a tent and had sex with him. Would have never done this. So at least the police in that case interviewed a number of people, but they were like summaries. I went and re-interviewed everybody, then had to subpoena them myself. 7 witnesses who gave all the exact same evidence about the complainant's actions. Mm-hmm. She sat on my client's lap, started talking to him, playing with his hair, twirling his hair, talking to everybody there, making sexualized comments, started to kiss him, and then eventually she led him into the tent, okay? And then came out, and not only when she came out was she like, she was pissed off because the client went to sleep in the tent. She came out, jumped on another guy's lap, the camp next to them. I had a witness from there who had no connection to our people. So that's direct evidence of her actions and, frankly, her state of mind, with all due respect. And it just shows that it went on and on about how I would never behave this way, I would never behave that way, I would never do such a thing, I would never do it with a stranger, I would never do it in circumstances of an event like this because I'm too vulnerable. It had everything under the book. Mm-hmm. And if I didn't have these witnesses, it would have been an issue. But this was a classic study on how you refute this evidence, but how it's absolute bullshit when people talk about their assumptions and beliefs and attitudes when you don't account for the fact that alcohol obviously
changes the way people act.
And the context of the situation changed it. She was not sitting in somebody's house. Yeah. This was not a classroom. This was not, she was at this event. She'd gotten there a day early. She was having a ball. There was a very festive, communal attitude. Everybody was getting along. So the context in which all this occurred was as relevant as the fact that she was drinking alcohol.
And it's similar to like what I mentioned earlier. It's like somebody goes like, I was dancing on a table. You'd be like, I would never do that. But then there's like 20 people who were present who can say, no, you were up dancing on a table.
That's why I think it's dangerous that they have to be careful about, her attitude towards the accused, any of her, and I'm not saying that the Supreme Court of Canada, pulled this out of their ass. This is mentioned in case law. Sorry to be so crass, but the reality is you've got to be careful about equating this with much weight when you don't account for the fact of alcohol, and you have to be able to give allowance to the fact that whether it's circumstantial evidence or you want to call it direct evidence, the evidence of an accused and other witnesses is highly relevant and probative.
So you can tell me if you agree or not.
Okay.
But paragraph 80, I see at the end of that paragraph that they compare an accused right to silence to their right to not have to testify in their own trial. They compare that as being similar to a complainant not being able to testify because of a lack of memory, and say you can't hold it against her credibility in the same way as an accused, for the same reason you can't hold it against an accused if they choose not to testify.
I guess you can read it that way. I mean, it's unfortunate language again. This process is really no different from when the Crown tries to meet its burden of proving criminal intent when the accused exercise their rights to silence and have not provided any direct evidence of their subjective state of mind. So I understand what you're saying. What they're saying is the Crown would have to do it by circumstantial evidence, right? Mm-hmm. And that's often the situation. And you can draw direct inferences from the actions of individuals and presume that they intend to do what they've actually done. But it's different when you're dealing with consent. So a person's right to silence is a legal right that can't be used against him for any purpose whatsoever because it's an enshrined constitutional right. An absence of memory is a fact that has to be determined at trial and may be an issue of reliability. So if you have an absence of memory or a blackout that you're professing to as a complainant in testimony, that's still something that may be up for a matter of consideration as to whether that's credible or not, because you may be feigning your memory loss or your blackout for all sorts of reasons. It is not remotely similar to a constitutional right.
No, and that's,
I get what you're saying. Sorry, I understand what you're saying now. So, okay.
But like you're saying, is like they may be feigning a blackout, whereas an accused doesn't feign their right to not testify.
Absolutely correct. Now I understand what you're saying. Yeah. I think, again, the bad language was that where adduced and found to be reliable, a trial judge must consider a complainant's circumstantial evidence of non-consent or incapacity in cases of memory loss or blackouts. 2 decisions from this court confirm the Crown may establish the absence of subjective consent through the use of circumstantial evidence in such situations, whether from the complainant or other witnesses, and from times often when the sexual activity was said to have occurred. So they're talking about use of circumstantial evidence. Yeah, I agree.
But
so I understand what you're saying.
The comparison to an accused right to not testify was
bad.
Totally inappropriate as far as I'm concerned.
No, I agree. There's no reason to say it.
Yeah. And I know one of your biggest peeves about this decision, I was going to say pet peeve, so it's not a pet peeve, it's an actual concern, is that the decision at paragraph 85 reinforces that a complainant's evidence is not to be treated as unreliable merely because of a memory loss or blackout. And the choice of the word unreliable, I think, is unfortunate because it's absolutely connected to reliability. Credibility, maybe not. They wanted to say she shouldn't be seen as less credible just because she experienced a blackout, maybe by her own fault, maybe by somebody drugging her. Credibility isn't necessarily at stake, but reliability is absolutely at stake.
Well, reliability is 100% at play. And I guess what they're just trying to say is merely because there is memory loss or blackout, you can't acquit, right? So I guess what they're trying to say is that if all you have is memory loss, whether through whatever they say, a memory loss or a blackout, a court can't automatically conclude, just based on that alone, that a complainant is not reliable. I would agree with that, but it does raise reliability issues, right? Because often it cannot be a case where you have a really solid memory of certain events and then all of a sudden it goes, it just disappears. So it's usually the description of events is all impacted by the memory loss. So, we have to give concrete examples about this, but okay, so you're saying that after you had that drink, you then went and danced with him. How are you dancing? I don't remember. Do you remember putting your leg on him? I don't remember that. Do you remember this? No. But then after that, I definitely told him that I wanted to leave at that point. So you have a juxtaposition of certain memories, not others.
From remembering saying that one line, I then have no memory of anything else until about an hour later.
Right. So that happens. Like, I get that would happen when somebody.
It was a sudden flashback. I know the precise words.
The onset of a drug. If I'm correct in the science, it is not simply that. There will be an onset to some extent of feelings.
Experiences of dizziness or disorientation or whatever, right. Yeah.
There are other, the memory loss will factor into reliability on a number of evidentiary issues as you go along the evidence itself.
Yeah, and of course it's more difficult when there's no witnesses, but
it's very difficult when there's no other witnesses.
When you're in a park and there's other people, you're at a party or something like that, there's other people around who can say whether or not you fell over a rock, whether or not you got carried like a sack of potatoes.
But that's why WD is so important. If you've got a case where there's simply a complainant's evidence and accused evidence, and she doesn't go to hospital afterward, there's no evidence of injuries as a result of this, meaning she fell down, hurt her knees, carried like a sack of potatoes because she dropped or whatever on the ground. There's none of that. So, it's a very difficult analysis, and that's why WD is so incredibly important. Yeah. But that's why I think language here is a bit reckless. But
so in terms of the lemonade, the small little bits of things that I think, can reinforce.
Can we just discount this case? In other words, can we just say, restrict it to the fact that they were just dealing with this one case where the judge did not take into consideration the whole of the evidence and all the circumstantial evidence that the complainant testified to, and just limit it to that, and just simply say it doesn't change the test on capacity, doesn't change how we look at consent, doesn't change, really how evidence is direct or circumstantial as to how she consented or not consented. Can we ignore
this? It still leaves open a number of things. So, like in paragraph 60, underscored, they say the inferences to be drawn from the circumstantial evidence depend on the nature of the evidence, the live issues, and the theories of the parties. And that statement actually clarifies that this is a very specific fact-based analysis of the judge failing to consider. So what the judge did in this case is he said, I have no direct evidence from the complainant about what she was doing or saying or whatever. So the only evidence I have about what happened was from the accused. The failure there was that there was circumstantial evidence from her leading up to the blackouts. And,
my reading, but I can't go into it. I mean, he did take into consideration certain aspects of her
there were some,
circumstantial evidence. But I don't think it was a...
But there was a blanket statement saying that the only evidence before the court was the accused evidence because the complainant had a blackout. And there was circumstantial evidence. So it was very case specific. And I think that's important.
I think what he should have said is, but much of this circumstantial evidence really doesn't assist me for the following reasons.
Should have said, yeah. And that would have explained it. And, there were dissents there where they said we have to be very careful overturning acquittals because there's deference paid to judges, especially when there's convictions.
Right.
They're really big on, let's defer to the judge on that one.
Oh, no, there's much more deference on a conviction.
So, but it's important that they did clarify that cases are very, very specific in terms of the nature of the evidence and the live issues and theories of the parties at that specific trial. And that can be helpful when our clients is testifying and the Crown wants to discard their circumstantial evidence, to keep it case specific and not allow these, paragraphs that are inconvenient to either side to be taken out of context.
Okay.
So then I also had noted paragraph 66, the absence of capacity to consent does not vitiate the complainant's voluntary agreement to the sexual activity. Although I have a note, this is very confusing. They say, instead, capacity to consent is part of what makes the consent voluntary. It seems like a circular sentence to me. The Crown may establish the absence of subjective consent by proving either that the complainant was incapable of consenting or that she did not agree to the sexual activity in question. And I found that really confusing because they outright say that the absence of capacity does not vitiate her consent. But then if the Crown can prove absence of capacity, then her consent is invalid. So,
if you don't have the capacity to consent, there's no consent. Period. That's the law.
Yeah. So paragraph 71, I had underlined, they point out that subjective consent is personal to the complainant, that it is, does not mean that the only direct evidence from the complainant about her state of mind at that time can be relevant to subjective consent. Again, that's reinforcing what's often overlooked in a Wanchuk. And we mentioned this earlier, but I'm just repeating it, that where consent was originally said to be subjective in the mind of the complainant, it is still subject to a credibility analysis. And the subjective testimony about subjective non-consent must be believed by the trier of fact.
Right, and importantly, that the subjective consent must exist at the time the sexual activity occurred does not mean that only evidence about that precise moment in time would be relevant to consent, in fact, or capacity to consent. So, of course, other evidence will be relevant. But that's why I talk about there can be direct evidence from a complainant, from an accused, or for other witnesses about the actions and conduct, the actions and the words spoken of a complainant that would be relevant to establishing, frankly, consent.
Yeah. I'm really sad to say, I thought I had more lemonade, but that's really it. This is actually a whole bunch of lemons.
Yeah, and I think, I'm hoping, I think we can restrict the case. I've calmed down in a few days now after reading this, and I think there's a way that we just restrict this to say it's very subjective it's very fact specific, and the wording is used in relation to how they're dealing with overturning the acquittal and ordering a new trial. It really doesn't recast at all how we deal with consent or how we deal with capacity, in spite of some of the unfortunate language which
I don't
is
have
used.
the paragraph number, but there is something in there where they say that they're not directly going to deal with whether or not the Crown has to prove evidence of drugging. They say this isn't the case for that. And, that always pisses me off because, you got an opportunity. Why not give a little bit of guidance on it?
Well, they may not have felt that they had a proper foundation in this case, but I think it has to be, we have to be very careful to say that someone's feelings alone about being drugged in the absence of any sort of other evidence to substantiate that is not something in which you can conclude, because it's so easy to say I was drugged. We've seen this with other complaints and cases we've won, where it's so easy to say I was drugged, and there's no fucking way they were ever drugged. I mean, we had this one case where they executed a search warrant within hours of the alleged sexual activity and scoured the house, seized glasses, seized the bottles of alcohol, seized clothing, bedding, everything possible. There wasn't a trace anywhere of anything.
And the description of the effect of the alleged drugging, the Crown, when asked by the judge, said, I can't think of any drug that acts in that manner.
Right. Well, good for the Crown in that case.
Yeah.
But that's right. Because we knew from...
Well, good for the judge for actually directly...
Well, she understood that because she knows about the pharmacology of many of these.
Yeah.
Because we deal with this on a regular basis. All right, I think we've beaten this case to a pulp now. So
to lemonade. We beat it to lemonade.
No, I like lemonade. So I think we've beaten it to like a neutrality, maybe. So I hope it was helpful. I hope this was interesting, because I thought some of the comments actually, when on the last podcast, people were quite concerned about it.
Yeah.
And
but we had the Kruk decision, which we thought was not necessarily great. And then
no, but our first response to the Kruk decision was, "Oh, common sense is back.
Common sense.
This isn't so bad."
And that's the main reason that case is being cited now, is that one thing saying, of course, judges need to use common sense.
Right. I mean, I saw that. You and I saw that right away, and I thought that's a very good comment. And then, frankly, they said something unfortunate about the rarity of fabricated allegations. But Kruk, also said, motive to fabricate, although may be rare, must be considered by a trial judge, and if not, it's a reversible error. So there was really good, clear statements that was of assistance. But
yeah, so we'll see how this case gets cited.
Do you want to do pillow talk?
You want to hand me one? I can read it.
You can just read it.
Hey everyone. Well, actually, we should thank our sponsor.
Yes.
Which I can't remember the name
EasyDNS.
of. EasyDNS.
Thank you, EasyDNS.
It'll make your life a lot safer, and it'll put your mind at rest when you're surfing the internet, as we all do. And don't forget to like, comment, subscribe, and share on this video.
And please send us your...
We do read your comments.
Yeah, and your suggestions for topics. So we really enjoy reading them, and we want to respond to them. And soon we have a guest coming up on digital evidence. We'll get that one done soon. It's going to be a really interesting episode. So thank you for your viewership. Have a good night.